We know you did it! This DNA report says you handled the murder weapon. Don't say a word. That report could be faked. I'm attorney Andrew Flushy, and today we're going to talk about how the police are using fake evidence to get you to confess. In some states, using this fake evidence is completely illegal, but in other states, like Virginia, it's quasi-legal. Just last year, the police in Virginia Beach were caught using fake DNA reports to try to induce suspects to confess to crimes. Apparently, these police officers used a fake mock-up of the Department of Forensic Science letterhead and made it look like it was some kind of DNA analysis. It was so convincing that prosecutors and even a judge couldn't tell the difference. The scheme was only uncovered because a prosecutor reached out to the Department of Forensic Science, our state crime lab in Virginia, trying to get a certified copy of one of these DNA reports. Of course, no such record could be found by the department. If prosecutors and judges can't tell that the police evidence is fake, you certainly don't stand a chance, especially under the pressure of an intense police interrogation. The Virginia Beach police maintain that they did nothing wrong, and they're actually sort of correct. How is this even possible? The Virginia General Assembly just last month considered a bill that would make it illegal for the police to use this fake evidence in their interrogations. The bill failed. So if using fake evidence isn't explicitly illegal, what protects you and I against the police using such evidence during their interrogations or investigations? Thanks to the United States Constitution, nationwide, confessions must be voluntary in order to be used against you in court. An involuntary confession would be inadmissible in court because it runs afoul of the Fifth Amendment. If you, or a great defense lawyer, challenges the voluntariness of your confession, the court is supposed to analyze the totality of the circumstances in determining whether or not that confession was voluntary or involuntary. But different states have different opinions about how big of an impact fake evidence should have in this analysis. In a New Jersey case, a police officer posed as an eyewitness who saw a suspect at the scene of a murder. The police used that eyewitness to make a fake audio recording as if he was telling his story to the police. The police interrogators used that recording to compel the suspect to confess to murder. The New Jersey court ruled that was an unconstitutional tactic and excluded the confession as involuntarily made. After that trial, the state of New Jersey adopted what is known as a bright line rule, where they specifically said under law that that is an illegal tactic and they've banned the police from using fake evidence. Florida did the same thing back in 1989 after the police used fabricated lab reports to induce a confession in the State versus K-Word murder case. But many other states, like Virginia, simply rely on the totality of the circumstances test. This means that the police using fake evidence against you is simply one factor of many that the court will consider when determining if your confession was voluntary. So technically, in Virginia and many other states, fake evidence could be used by the police to compel you to confess, and them doing so does not automatically render your confession excluded from court. What if you were in one of these states, or you're not sure where your state falls at all? How do you try to protect yourself from these traps? Just because the police claim to have evidence against you means nothing. Police routinely mislead suspects about what they have or what they know in order to induce cooperation or an outright confession. In many cases, the police need you to fill in many of the gaps in order to make their case. Even if you see tangible physical evidence that's allegedly against you, don't blindly believe it. It very well might be fake. If a police officer ever reads you your Miranda rights, it's time to lawyer up. That is your signal that you are absolutely a suspect in a police investigation. If you're being interrogated while in police custody, you have the right to have a lawyer. There are some exceptions, but if you're told you have the right to have a lawyer, you have the right to remain silent, ask for a lawyer. That simple request may shut the police up, and it might cease all questioning if a lawyer is not available. And if you have a lawyer at your side, your lawyer should be able to inspect any alleged evidence the police have against you, and they should be able to help spot a fake, or at least help advise you of what you should do at that point. After you've asked for a lawyer, shut up. You don't need to repeatedly ask for a lawyer, and you don't need to repeatedly say you're not going to answer questions. You don't need to try to dodge questions. Just shut your mouth. At most, you may want to simply say, I'd like a lawyer and I invoke the Fifth Amendment. By specifically invoking the Fifth Amendment, you're indicating that you are absolutely invoking your right to remain silent and then remain silent. The more words you utter, the more likely it is that they could hurt you. So lawyer up and shut up. If you want to protect yourself from other tricks that the police use, check out my next video where I walk through some of their favorite tactics. I'll see you over there. And remember, don't talk to the police.